Russ,
If you have a couple of minutes after this meeting, I would love to have a quick chat. Finalize one of the originals and
Yeah, I was curious
I
where we were on the one that we finished.
I want to circle back.
Okay.
one of every time.
It won't take long, just a few minutes. They don't seem to be live.
Okay.
They don't seem to be.
Yeah. Okay. That's, yeah.
I'm at the 5th, so I have Dallas calling.
So you got live.
Switch.
Oh, there's. Getting all new furniture after this meeting today.
Oh, really?
So
Oh,
all of
really?
these should work.
But they don't seem to be working now.
There's no power right now.
Yes.
Correct.
It's. So here is our strip that's up here, Kelly.
We have a
Usually it's up
cord over here and a cord that's going
These
up.
don't work.
What are we doing?
We do. Yes, ma'am.
Okay, so we have a forum, so we're gonna go ahead and begin, and we're gonna start by introducing Frank Baker, the CIO for the Office of Court Administration. You know, Casey has retired, and Frank courageously has stepped into the fray. He's here with us for his first meeting, and I'm going to ask Frank to tell us a little bit about himself.
Sure. Thank you, Justice Simmons. Frank Barker again. I came from Texas ERS. Previous position, been in state government for around 15 years, total 16 years, 33 years in my profession. Lots of experience with different projects, different endeavors on at the court infrastructure person versus, you know, the other side of the house usually is development. So I have a lot to get up to speed on, you know, with vendors, with the judicial system, with court needs. But I really look forward to working with y'all to figure out what those needs are and what I can do to help enhance the systems and your ability to do your jobs.
All right, so welcome, Frank. We look forward to really working with you. We're going to start our meeting by looking at the meeting minutes from the September 2025 meeting. If everybody has had a chance to look those over, they were sent out a little later than usual. Apologize for that, but we'll get on a good schedule for our next meetings. But if you can look at that, or if you've already looked at that, first, does anybody have any corrections, questions, or concerns about the minutes that they want to raise? And if not, do I hear a motion to
Their adoption.
Oh, all right, thanks, Cynthia.
Yeah,
Oh, gosh, you made it. You figured out where this building was.
Well, I'm here all the time.
Yes.
For law examiners. but-
Right, but we never call it, no offense, we never call it the park, it's like the first floor.
No, that's
conference room,
right,
right?
that's right. I was like,
Yeah,
what the heck is
yeah,
that?
yeah. So anyway, okay, so we have a motion. Do I have a second?
John Warren, a second.
Okay, thank you, John. All in favor, say aye.
I,
Aye.
All right, so we have adopted those minutes. All right. Okay, so the first thing we want to do is what was also sent out were the review of the committee, they were basically the committees that have been set up. Just as a reminder, those get usually looked at and reviewed every year. And normally we do that in our September meeting. But I don't know that we did that. So I just want to tell everyone they have that. If you don't like your committee, we can put you somewhere else. Remember that you probably will be appointed to a variety of committees as we have our meetings, as Tracy well knows. She's the queen of many committees. And so, but please, if you don't want to raise it now, be sure and just contact me and let me know, and we will try and give you what you desire in terms of committee appointments. Bob, do you have anything that you want to say about committees?
No, I think that's it.
All right. Okay, so basically what we want to go to now is basically talk to each of the committees and whatever to kind of figure out what's going on. And we're going to start with you, the standards committee, Bob.
Okay. We're gonna launch with this year with a couple of projects that were discussed toward the end of this past year. The first one is dealing with, there's been a suggestion that we look at the current uniform case management standard that were developed targeting counties of 20,000 or less, but basically say, what are the minimum requirements? What are the minimum things that a case management system should be able to do in Texas? It's been suggested that we get a group together and take a look at those requirements, see if they need any updating, any amendments. And then, once that's done, consider adopting them as recommended minimum standards for case management systems. So that when counties are going out and looking to upgrade a system or make other changes in their case management strategy at home, they have something that they can look at and compare what they're thinking about versus these minimum standards. And I want to emphasize minimum standard. This isn't about replacing or requiring people to replace something. It is trying to set a baseline of things that every county's case management system, regardless of where it comes from, should be able to do. But again, it would be done as recommended.
So Bob, can you kind of explain, the issues that this is trying to address?
As you know, Supreme Court adopted an order that sets some requirements and some timelines for the just automatic distribution of orders statewide. Many counties have run into challenges, and in fact, we still have some number of counties out there who either their current vendor can't provide it, or in looking at this, they decided it was time to change case management systems. One of the things that we discovered through this and came to light is how many case management systems up there were acquired in the early 2000s. One in the late 1990s. And so you can imagine the difficulty that presents in trying to link those folks or bring them into any of the things we're doing today or that most counties are doing today. Which actually is what brought up the suggestion about putting out some minimum requirement standards for folks to take a look at. There are also some other issues floating around out there where vendors are saying, well, in order for us to do that, we need X amount of additional money on top of the maintenance contract that you already have. And everybody in this room who's been around state government knows that county commissioners, clerk's offices in particular, sometimes aren't high on the list as far as additional and or new funding. So these are the things that we've discovered, and the more folks talked, the more it came back to, we need to put something out there about what a case management system should be able to do.
So your standards committee is addressing that, and how are you going to do a report out to the committee after you kind of develop these so that we can all take a look?
Yeah, we're going to get together a group of people, and it will include folks other than ours who are just on the standards committee.
Okay.
Frankly, an awful lot of clerks say. To go through them. I don't know that there's that many changes to the existing requirements that are going to be necessary. Certainly, there's some reporting updates. There's some things like that. But as far as the actual functional standards and requirements for what those systems should be able to do, I don't know. Given the target counties that were used, 20,000 and below, that there really are that many changes. But we just need to get some eyes on them and take a look at them. Standards committee would adopt them and then bring a new set of minimum requirements to JCIT to recommend for adoption by the Supreme Court. But again, as recommended.
Right. So Bob, are you going to contact any additional people that you think you want on that committee?
Already have a list.
You already have a list. Is there anybody here that wants to be on that committee that maybe we haven't considered, but you haven't considered?
I'm not volunteering for the committee, but I do think it's important to put some context to this there was a statute that was passed, it was attorneys that were complaining that orders were not being
Right.
served on them electronically. And there was actually a statute passed that said that they had to be sent through the e-filing system. And it was a little bit of a surprise. I think it got tacked on at the very end of the bill. And there wasn't a lot of discussion on it. I think the state was able to give them a lot of feedback about this. So we were all a little bit surprised that it came through.
Okay.
The court talked to the legislature, and fortunately, because our appellate system, we were already serving orders electronically.
Right.
The court talked to the legislature, and they said that was okay. They weren't to be upset. The rule did require the appellate courts to send the notices through the e-filing system. But as I understand it, the trial courts are currently having to send their notices through the e-filing.
Yes.
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 Correct. And so they are being sent out. I was personally surprised that this wasn't kind of a basic thing that was already built in all these case management systems. But I just want to point that out because it would require still a statutory change, even if we make a recommendation. Right? Because it's still in the notice that, well, I don't know what do you think, Megan?
What do
Well,
you would require
if
a
we-
statutory change?
Well, the statute's still going to say you have to send it through the e-filing.
Yeah, we're not trying to change that.
Right, but even at the case management systems, if you add that to the standard, we still have the statute out there. Is the statute.
Oh, right, yeah. But the-
Process, yeah.
But the
I mean, I
case
think it's a good
management system
idea.
just facilitates
Yes.
the ability to comply
So I just-
with the order.
And this really came from a legislator who practices in multiple counties and was frustrated that in some counties, they were sending to notices, in other counties, they were not. And so, it was really important to him that
Yes.
this is clear that every county had to do it.
Let's go through Research Texas, right?
Is it Research Texas?
Yes, it's Research
Yeah,
Texas.
Texas.
If they're,
If
If they're integrated.
which,
and a majority of them want.
Yeah.
For
And
one
if,
case.
and if they're not integrated, then what's the solution there?
Sarah, can we get a copy or can somebody tell me the name of the Senate bill or House bill?
2 sessions ago, I'll look it up.
Well,
What is
waiting
it?
to be able to hear Mark, what I wanted to mention, it's probably not an order, but in state writs at the trial court level where they're filed, because you can have witnesses and so forth, even though the Court of Criminal Appeals ultimately decides them frequently. Recommendations, findings of fact and conclusions of law are not served on the defense lawyers or the prosecutor. Appeals without either side being aware of.
Documents be served and sent to us in a record.
Well, to y'all, but the lawyers aren't getting, it should be.
It's still a service requirement. So that's a problem, that may be a problem with the trap rules and compliance with the trap rules,
And
but
I
there
don't
should be a
know
way
if,
to
if
resolve
this,
that.
would I don't know if your standards would apply to writs in criminal cases, but, you know, we ought
That
to
would be
address
up
that
to the
somehow.
CCA, yeah.
Yeah.
Because we haven't done a mandate in some areas where the civil cases have. So
It's happened in Dallas, Fort Worth, Bear County. It happens quite frequently where it bypasses
Email
everybody.
address.
So it seems like it's more a rule or a procedure for the Court of Criminal Appeals as opposed to the standards for,
It's not a standard.
yeah, it's not a
Okay.
standard for what level of equipment you need to have,
And it-
whatever.
yeah, it may wind up being a mix, but
Okay.
having the ability to do that would be part of the standard.
Yes, I agree.
Being
Accommodate.
held to do that.
Yeah.
Is something else, but there is a trap rule,
Okay.
that
Requires it be sent to you.
requires it be sent to us, but documents are supposed to be noticed on all parties. So that's a violation of.
Yeah, that's what I was gonna say. So in other words, there should be the accompanying, if you're gonna serve it on the court, the lawyers ought to be
Yes.
getting the material. So I see what you're saying. So,
There's some hiccup going on.
so is there, yeah.
So the case management system's not doing it. One, obviously, there's the cost, because they want more money to add this feature. But one would think that when you have to do this legislatively, that would put pressure on them to be like, oh.
It is, and we're talking about now, as we sit here today, a very small number who aren't in compliance. And if you say, of those who aren't in compliance, how many of them are moving to a case management system that will do this over in this next year? What do we go out to, April? And that last extension for some of
Yeah.
the smaller counties? And you say, okay, they're on the way, they're gonna, working with their vendors, as soon as they get it up and running, then they're off the list. That brings us down to a very small number.
And this is just really a way to assist them if they probably are a very small small office. That if they now know that their machine, they need to upgrade, this just gives them kind of an idea of these are the features, so what's the cost, so they can go to the.
I agree. It should be-
So I think it's
I agree, it should be the standard, and it sounds like the only thing you can play is just cost. Would that prevent us from putting it in the standards?
No.
No, I think we put it, just a recommended model requirements needed, to facilitate all of the things that are currently required. You know what I mean? Just as a way to
No, I
say,
agree. I mean, I think it should be,
Yeah, I
I guess
mean,
my
yeah.
question is,
Think
do we
of it
really
really-
need to study it further or?
no, it's just, we were just talking about forming a committee to develop what are those standards?
And it's actually to review what we have.
Already have.
The requirements we already have and see where updates may be needed. To get those in.
Because I would vote today to say, yeah.
Okay. All right. Yeah, no, that's it. This is more just as a courtesy, as a help, as an assistant to the counties. And I think we're just looking at it because there've been a couple things like the orders that are going out and stuff, making sure, okay, do the standards that we are recommending right now. Will that be sufficient to cover these kinds of additional requirements? So it's just a
Yeah.
review, right?
Yep.
Right.
The second piece is y'all recall last year, the committee adopted some criminal document types to go into research. And it was the basic filing documents, complaint information, indictment, and on the other side, judgment, sentence, and order of dismissal. Basically, so under this theory, the public could see what was the person charged with and what happened to it. Since then, there apparently are those who would like to see additional documents added to criminal cases and be available through research. And while folks have talked about that, no one has sent us any specific recommendation for what document or documents they'd like to see added. So what I'm
I'd like to
asking,
take that up and try and survey the different associations and get you some kind of.
yeah, that's the thing. We need to have something to act on as opposed to just picking and choosing random documents. What is it that folks, either in the legal community, the courts, the clerks,
What are they already
would like
doing?
to
What are
see?
the clerks already displaying in terms of criminal information? Do they all just only display what we're doing, or are they some counties that have broader sorts of information?
Catch Ken right now. I think every county's doing something different.
Okay.
Sometimes you can just see the docket sheet and you know
Yeah.
what to request from the clerk.
Okay, Cynthia, would you
I would be happy to get involved.
here to help on that criminal aspect? Anybody else want to help with that on the criminal side to see?
What'll be all part of the standards, right?
Yeah, it's part of
Yeah,
standards.
what we're thinking is once we get something to look at and to act on, we would do a joint meeting between standards and the criminal subcommittee.
Okay,
And that gives us folks, who definitely have an interest in that subject. It also gets you some judges, lawyers, et cetera, to take a look at that. and react to whatever's.
Yeah, I just would make sure you've got criminal input at the very start of this.
All stakeholders, because, you know, some counties have criminal law committees that have all stakeholders that belong and some don't. So I think I'd have to reach out to TCDAA as well as TCDLA to start off and then figure out who has law enforcement, probation, the corrections, defense, prosecution, clerk's office at their criminal law committees and who doesn't, so I can get as much input as possible.
Yeah, and at some point in that process, depending on what documents are requested and that joint committee agrees to come forward as a recommendation to JCIT, the question of, okay, who should these documents be accessed by? As you know, over in our current research, we have a matrix that goes through and identifies various levels of access. Right now, the documents we have shown in research and in criminal are all public. There's no question about that. But as we move into other documents, this issue of access may emerge. So
This is John Warren. First, Happy New Year, everyone. One of the things I want to, if you all recall, sometime I think early 2005, maybe, we had the discussion about access. And Bob, we in Dallas County, when we went live with our case management system and our criminal courts Odyssey, we went through that matrix to make sure that there was a clear definition of who should have access to what documents. But there also, for Dallas, we also kind of went through a justification. Why do you need this? Because in our mainframe, the way we were historically is that our mainframe was just a dumping ground. And if you had access to the mainframe, you had access to everything, which is not proper. And so when we went through that process of separation, and so I think we need to use that matrix and kind of like have it as a living document that continues to grow as we continue to add documents to it. And it could also serve as an audit, a way to audit case management systems and how we are able to provide access to, say, like, for example, you have the district attorney and who's part of the county and a criminal case. And then you have the public defender who was under the assumption that because they are also county employees, but that they should have the same information that the district attorney has. But for the district attorney, that's work product, and for the public defender, you're actually acting on. You may be paid by the county, but you're actually acting as a private attorney representing a defendant. And so there's lots of opportunities for where lines will be blurred or crossed, that we need to make sure that we are actually identifying exactly what is proper and what is not proper.
Yep.
Good points. Very
Yeah.
good. Thank you, John.
There's also some confidentiality things that I'm worried about, like, for example, in family violence cases, if it's clear that there's a victim that will be appearing for court on a certain day, and that information is accessible by everyone, that may be problematic. Like, so I would caution, right, I would caution that there's some information that we need to make sure that we talk to our partners about that want the information, and see what redactions or what information is truly needed and what level granularly that can be given to who.
Well, and now you know why we stopped with documents that are out there today.
Yeah. Yeah, there was a big little discussion about that.
Several.
Well, this will be
For
easy.
a very long time. Bob, can I ask a question?
Sure.
So is the committee just looking at like what should be published, or is the committee also looking at like the basics of standards of what should be in the case management system? Because as we're talking about, I know that there's a lot of cross work between some of the stuff that the the data that the judicial council collects and as we are moving towards collecting case level data, it is very difficult when there's no standardization in the case management system. So each field means X, X, Y, and Z. And because some across counties, they use it differently.
Right.
And so the committee is looking at that too, right?
Yes.
Okay.
In fact, my guess is when it's all said and done, aligning the requirements with the current OCA reporting requirements and definitions will be the most significant change to what we have today.
Those conversations are really tough conversations. We've had a lot of them over the years about how you, and even amongst our smaller group of appellate court clerks, it's really tough to get everybody to enter everything the same way, get your stats consistent. And it's going to be really difficult with trial courts. Legislation might even be necessary. I don't know if you have a certain statistics that you're trying to collect.
Well, and the judicial council has a role in this too.
Yes, and the judicial council by
and-
statute has the authority
Exactly.
to collect this information and what manner to collect it in. And they have for years have done rules on this.
So.
Yeah, one of the thoughts
I know
about
the
this,
vendors are asking for it
right,
too.
one of the thoughts would be for the judicial council to adopt a new and an updated set of data standards, data recommendations and definitions, and then we just pull that in by reference. That's another way that we could do it.
Or do we make recommendations and then the judicial council kind of looks to us in that area, or do we look to them in that area because they're the ones that determine how to implement the
Well,
requirement?
I mean, they have the authority to do it.
Yeah,
Ours is a recommendation.
right,
They can actually mandate it.
right. But in terms of deciding how to do it, are we the ones with the more expertise in that area in terms of collecting data than they are, so that we can recommend to them, this is how to.
Perhaps, I mean,
how to request.
That's something that the committee and particularly the people that we bring in from the various clerks' offices can advise on. But I don't see that the actual reporting is any different from a procedural standpoint and process standpoint than the reporting that is required today.
Okay.
It's just more granular.
So so when they're all reporting out this different data, what are the kind of requests that they're asking? Is it quantitative that you're asking for?
I think it's an issue in large part of what exactly are the events, as we call them,
Yeah.
you have to put in your case management system. So that then you can run standardized reports.
That's what I'm-
on them.
Yeah,
So say, for example, just something simple of how long did this case last? Or how many cases do you have, that sort of thing. And sometimes I don't know what all the different requirements are that you're looking for, but sometimes it's like, what do you call this case? Like what type of case is this? Or what do they call a petition or what, this sort of thing. So it's oftentimes what's the menu that the clerk's office has to
Right.
choose from when putting something into their system. Some of them like to be really granular and call every single motion by a specific type of motion name, which then makes it hard to do sort of standard apples to apples comparisons about how many motions do you have pending, how long does it take you to dispose of them, that sort of thing.
okay.
I mean,
Did that answer
You
your
have
question?
a drop down menu where this is your only choice. We only give you 3 motions.
Yeah, but that's the
Oh,
kind of thing
no,
we're
I
talking
agree.
about.
Yeah, no.
so that was my question is, has JCIT or any of the committees ever even gotten to that level of detail in recommendations that you're thinking of for standardization in a case management system?
I know that we had these debates about like in the e-filing system, like what are the menu options?
Yeah, exactly. And it's more dealing with what the drop downs are called and what the menu, how the structure the architecture, of how the.
And so obviously
stuff works.
we landed on, and I don't recall this, but obviously we landed on some sort of agreement about what they were gonna be.
Yeah,
But then you can still, within the clerk's office, change
oh, of course, the way you
the
deal,
way you
right,
put that into your system.
in your own system, yeah.
Yeah.
Well, and this is further complicated by what a clerk's office needs that processes 50 cases a year versus a Dallas, a Harris, any of the larger counties, their needs are significantly different.
Well, and just having been on trial court fairly recently, clerks in a large office, one clerk may put it in, every motion is a motion, right? Because they're backlogged and they are just gonna pick the word motion and that's all that's gonna happen. And then you have people who believe that they're helping by being overachievers and putting motion to withdraw, motion for this, motion for that, and they're gonna put in everything, right? And so
Yeah.
even within the same office, you're going to have clerks that handle, assistant clerks that are gonna handle it differently.
Yeah.
And I think a lot of it is driven not only by their practice at the local level, but I also think that when they're setting it up, it's the recommendation of the companies.
Really?
Yes, because we just did an implementation and a lot of the questioning was about what do you recommend? You've seen the practices across the state. What do you recommend? So I tend to think that if we want more standardization, because here's the thing, the companies can help. The companies may not hinder, they may actually help, but that guidance needs to come here or else they're going to recommend what they think like that county is looking for, or what those county practices have been, and how do I help this county, right? That may be different from a smaller county or a larger county.
Or they may
whatever
just it
be
is.
relying
relying on their past experience with
Right.
another county.
Right.
When they did this up here, this is what we recommend.
Yeah, and then OCA of course,
Yeah.
is receiving the reports and
Yeah.
collecting the data, and they're not in the room when those conversations are happening.
Right.
So, I mean, I think you all obviously would need to be involved in telling people like, here's how we would like to. get
We
this.
are working on that because we now have our regional data coordinator, so we have one in each administrative judicial region that is going out to the clerk's offices and helping them with their reporting. But I still think, as we're moving towards case level data, I mean, we already have a matrix and have been talking with clerk's offices about that. We're testing it with UCMS right now. There's gonna have to be standardization,
But I mean,
whether that it
yeah.
comes from
Right.
a recommendation from JCIT or it fully comes from the judicial council, there's gonna have to be
I think we have a
some
good,
official
because we have
document.
so many clerks and a wide variety of people here. I have a tendency to think you may want to, I mean, we may want to start that.
Collaborate.
Yeah, to collaborate with the Supreme Court, but to kind of work on that, just because we have so many people here that are so knowledgeable about these specific issues. As opposed to, yes.
I was just gonna, see if I could bring up one other thing.
Okay.
It's not only important to talk about this in terms of reporting data, but it's also important to talk about these same standards from the input process.
Yeah.
What we're starting to find out is so many of these things are tied to fees. So many of these documents are being returned for correction because the fees are not being paid. The substantive part of that is important.
Yes.
If somebody's bringing an appeal and because of something a judge did, you order a clerk's record and that order's in. If something's returned for correction because the clerk flagged it, it never shows up anywhere. In the past, I would go to the clerk's office and plop down in somebody's chair and say, I need to file these documents, and they would do something magic and write on a post-it note and finally come to a total and say, this is what you owe.
Yeah.
If we're filing all of that in advance and all we have is a drop-down screen where we're trying to guess on the screen how much it is, we're running a big risk that those documents aren't going to get through the first review stage. So I'll talk more about that in
Yeah,
the pro se side, but I think it affects really all filers.
So what you're saying is certainly there are systems that have very specific titles for documents. And that if you are filing and you're not using the set document name type.
Yeah, if I'm filing a motion for summary judgment,
Yeah.
that's gonna be treated differently than if I'm filing a motion for new trial.
Right, and you
Because
better
it's not-
have the words motion and summary judgment in it, right, instead of just motion
That's right.
to destroy the other side or
And
something.
again, that's a civil side
Yeah.
problem, but that's not
Right.
really a criminal side.
It's
problem.
not, okay.
But I was gonna bring that up because we had a request from Clarissa. To get, there is a new law in civil for the motions for summary judgment and a timeline
Yeah.
put on to the court to get that setting happen, but in the standards. We have nothing, we have we have a lot of different motions, but we don't have a motion for summary judgment. So, there was a recommendation by Clarissa due to the Senate bill, that was passed.
16.
Yeah, I think it was 16. But basically to add motion for summary judgment and summary judgment response relief, because those two documents, they're not tied to a fee, but they're tied to, you need to flag
Yeah.
this, and there's a time crunch, to get the settings, set for the court.
And they have to report.
And you gotta
Oh,
report
yeah.
on that
Yeah, the
information as
MSJ,
well.
the new MSJ, the new MSJ
Yeah.
rules
The new-
set the deadline.
Yeah, all the deadlines and for the new motions for summary judgment, so, so we need to add that to the standards. And the other thing I was gonna bring up is Casey did send us last year, a new version, a 10.1 version. That added the two new case types from the Senate Bill 441 and 2373 for AI. Civil case types. And he sent a draft version, a 10.1, but in August, but I never saw the Supreme Court approve that. So the last approval of the technology standards was in July. This was in August, and I don't think that 10.1 got sent. So that alone, yeah, I don't think they saw it. So that along with these two new motions for summary judgments, probably need to get in quickly.
Yeah.
Because these are already, laws are already taken effect, and the clerk's offices can't really, they have to manually, in our office, it's hard to catch all of those filings and know where to trigger and flag it. And we're trying to program it now to do automatic stuff, but we can't because I don't know when they file this motion, if it's a motion for summary judgment or just a motion.
Did JCIT approve those? Because if they approved them, he would have sent them. So, but has the approval?
I wanna
for
say-
JCIT
I thought
happened?
we
We
did.
did in September.
We did in September.
We did in September, but it never got to the Supreme Court.
And I don't
They
know,
could have sent it to you. So
I'm
we can,
assuming.
we can.
Yeah, can you
We'll
check on that, Megan?
Check
I
and
don't
see if
remember
it's-
seeing.
The new AI case.
The 10.1.
Yeah, the new AI
They're on,
case
they're on
types.
they're on the copy of the standards our support team has, so any courts that request them to be added, they can kind of match them, and say, yep, they can add them.
Right, but it's not been officially
Hasn't
signed
been
by
They
the
haven't
Supreme Court.
adopted.
Yeah, they haven't been
Right.
adopted.
But they were recommended by JCIT.
Correct.
Okay.
What I would suggest we do now, particularly with some summary judgment, is give everybody to think about it, but I would recommend that today we approve the summary judgment to be added to 10.1. Since it hasn't gone up. And get all that done at one time.
I would say,
I
assuming
mean,
it hasn't gone up, but Megan, you're gonna check on that, right?
Yes.
Okay, and so, I mean, if
Right. If it hasn't gone up, if we do that now, then we're not going to them and then a week later coming back with something else.
Correct.
Let's take care of it right now.
I have a question, maybe for Tracy, or does anyone have that document, that 10.1 document that they might be able to drop into chat? They have access.
I have it. Who needs it? I got the email from Casey.
Mark speaking.
Kelly, you're running that.
What document is it? It's the 10.1 technology standards. That
Yeah, Kelly
added,
needs it. Can you send it to her?
yeah.
Because she can add it into the chat.
And that's,
If I did it right, I put into chat links to the 3 cited bills, Senate bills. um, in chat.
Okay, so what is the anticipated time then of the submission of 10.1 if it hasn't been previously submitted? What are you thinking? With the summary judgment.
I think
With the summary, as soon as,
It was a summary judgment piece in there in 10.1.
no,
Not the
Not-
summary judgment.
not-
Okay, so then I think that the
That we
committee
need to,
would need to add that,
right,
and then
should we call it 10.2 though, or?
Yeah, I think it's, well, but per the legend, 10.1, he put in there per the Senate bill, back to it. It says adding two new case types to support Senate Bill 441 and Senate Bill 2373 from the 89th legislature. And he had that in there as 10.1. I mean, we could either, and he has August of 2025. So I think we need a 10.2 that then says added some motion for summary judgment per Senate Bill, whatever, and then have January of 2026 on.
but
So,
My recommendation.
Well,
but we need to find out about that 10.1
yeah, I mean,
first.
did it get published? So, I mean, the 10.1, I guess.
It did not
hasn't
get
been approved, it
adopted.
hasn't been
Nothing's-
And see that-
Nothing's happened.
I mean, is there any, is anyone having objections to adding that to 10.1?
that's what I think we ought to do.
that's what I think.
We can,
That
yeah.
we could be amended
Yeah.
10.1.
Yes.
Because it sounds like it hasn't gone before, at least in thoughts.
But you're gonna check on that, right?
Yes, but I mean, either way, we can submit
Yeah.
the updated version
Yeah.
for their consideration.
Do you call it amended 10.1 or you just,
No,
here's
it's
an
called
update?
10.1.
It's
They
just
haven't
10.1.
approved it.
Okay.
Yeah, just
Well, I
update.
think it was 10, so it's just.
But I do think we probably ought to have a motion, which I will make,
Oh, yeah.
to add summary
Okay, well, I'll make a
judgment to
motion,
10.1.
I'll make a motion to add it to 10.1.
Second.
Okay. All in flavor, all in flavor.
I
I didn't have breakfast.
I did notice once you get down to the matrix.
Ma'am.
Document, the matrix is all messed up, so I don't know what he did. But you might have to go to 10.0 and modify that and not use this document. Because
Sorry.
matrix, it's all messed up.
Okay, so can I have an amended motion then to revise 10.1 to include summary judgment and also to fix whatever is at issue with the matrix?
So moved.
Second.
All right.
It's motion for summary judgment and summary judgment response relief. There'll be two subsequent filing types that an attorney would pick to file into the case, and then the CMSs can trigger off of that subsequent filing type.
Okay, so it's motion for summary judgment and motion for what?
Summary judgment response reply brief, because one time clock starts when the motion for summary judgment is filed,
Right.
and another time clock starts when the response is filed.
Okay, those are two different things.
Two different things.
That's what I was gonna, after you said it, I was like, that makes sense. It's one. I didn't understand that at all. Okay, thank you.
Let me, I'll send this to both of y'all so y'all
Yeah.
can see
So-
Clarissa's email.
So that needs to get added to the e-filing system?
Correct.
Is it a choice?
Correct.
Oh, wait. I mean,
Okay, talk to
we're
me.
not gonna- I mean, it needs to be there, but just thinking of all the problems we have with ladders, not picking the right
Right.
thing,
Correct.
and they're not.
Well, right now, there's just motion for contempt, enforcement, new trial, modify, reinstatement, and revoke. Stay, terminate, and transfer. So there's no summary judgment, no
And with the time
response.
crunches that are on the summary judgment now, that's why that might need its own little designation.
Yeah, I mean, maybe there's nothing we can do about it.
Can I speak up?
Yes.
I realize the precipitating cause is the new deadlines for motions for summary judgment, and we do need to address that. But there are other motions that have automatic deadlines. And while I think, yeah, since 10.1 hasn't been adopted by the Supreme Court, there is perhaps a good reason to try and update it before they do adopt it. We still might want to go back and make sure we're capturing some of those others. Like the one that comes off the top of my head right now is a TCPA motion to dismiss. That triggers some statutory deadlines for hearing and for ruling. And so if we're updating our case management systems now to add the capability to track those, we might not want to do this piecemeal. We might want to have one of our committees go, okay, let's figure out what are all the motions that have some statutory deadlines. We've got motions new trial, it sounds like already in the standards, but there can be some other motions. So I'll just throw that out there.
But this is an excellent example of how these conversations go. Like, you want to add one thing and then other people want to add
So
more things.
my
It's
understanding-
very great.
Right, so my understanding is the need for, because for those, right now, they don't have to be reported. There's no report that has to be done on the motion, Dan, that you were talking about. Yeah, the TCPA motion, but for the motion for summary judgment, the clerks have to now keep track of this and report this information. So I don't know if that
makes more sense.
makes a distinction in the discussion that y'all are having, but there is that
There's gonna be
the clerks are gonna have to
reporting
report this information and they don't have any details on it right now.
I think we should move ahead on what we've talked about this morning. In many of the conversations that we've had before around this particular topic, at some point, somebody always says, well, how many motions do we want to put in the standards? We could have a list of, and then people just start throwing out numbers. So having some way to distinguish what motions should be in the standards, reporting, tracking required, et cetera, would seem to make some sense as opposed to just going through and looking at every possible motion that you could have.
I think that makes sense. I think the idea that you have to track these anyway and come up and report out, to me, makes it worthwhile, definitely to add that.
Is the reporting done through the case management system though, or through the e-filing system? It's like
If the case management system.
case management system. So really you have to have it in your case management system.
Right.
It's not so much that the filer needs to be able to choose it. It's that,
No, they have to choose it, otherwise then it's required on us to read it and figure out, oh, this is one of these and change it. We
yeah,
don't want to do that. We want the attorney to say, this is my motion for summary judgment, or this is my response to the summary judgment. We don't want to have to figure that.
yeah, and I would say that's too the difference between really high volume court like yours.
Yeah,
And smaller ones like ours of the public courts, we just want a motion in the e-file system. Because we don't want all that granularity. Like,
Yeah.
we can just.
yeah, because you don't need all that right
Yeah.
there.
And we don't have this kind of high volume that you're talking about.
Yeah.
where you have to churn through a lot of files.
What's the downside then for standardizing the motion for summary judgment response? What's the downside? Just that you have to take more time to input.
I think it's dealing with the filers.
Yeah.
They get confused and they pick the wrong thing. And there's no guarantee that you put them together. The data is gonna be correct because they're gonna be picking generic motion a lot.
Yeah. It's really,
Education to
Oh,
law.
yeah.
very hard.
Absolutely.
I mean, we tried to do this for example, for the business court, we tried to look through e-filing data for just in preparing for the volume, what their volume was going to look like. And we did it based on the dollar amount and people, they're not checking the right dollar amount or even the right case types.
Right.
I think sometimes the filers are staff people with no knowledge of the law whatsoever. And that's why a lot of that's probably happening. It's like, here, I'm done, this is ready to go. File it, and they're doing the electronic part, not.
Yeah, I think
Got
that's
some-
probably the majority.
Yeah.
It's staff members doing the filing, the attorneys are not. Which I don't know that that would be a guarantee that they would get it right. but-
No, that's right. No, you're right.
But yeah, and it just, it generates more phone calls because you have to return things or they're confused. They call and ask what type, what. So
Yeah, some attorneys couldn't file something electronically if their lives depended on it, right?
Yeah, but yeah, it's just odd to me because I have never seen, and I mean, just on the trial bench or, you know, the appellate court, or anything else, a motion for summary judgment that did not have that style.
Right.
Did not have that.
Yeah, I mean, I think it's
So it's
just,
interesting that somehow it doesn't translate to filing.
I would be shocked and appalled, but,
Yeah,
no, I mean, so the more choices you have, the more confusion you have, and the more phone calls.
the more errors you have the
The more
ability
errors, yes.
to instill into the system, yeah.
If
Okay.
if I can, I have a question, and it's been forever since I've looked at actually gone in and actually accepted a case through e-filing. And so, and we're absolutely right. We cannot have, and with the confusion, we cannot have pages and pages of options as it relates to motions to select from. But if we had just like a few standard summary judgment being one, but all others, is it possible to have kind of like another field where you have motion and then you just put in the description as it relates to what the attorney has
Yep.
titled that motion, and the clerks just enter that? That would actually reduce a lot of confusion, phone calls, and clerks' offices having to search to find a record when the only thing they have to go by is the word motion.
I actually wonder if we need to get our standards in now so that we can get the process going, but I'm wondering if something we need to think about long term is what makes the process better from the filing process?
I agree.
Rather than giving me a list of drop downs and hoping I pick the right one, and that the clerk agrees with me that my drop down is actually what the clerk wants.
Mhm.
Is there a way to proactively say, what are you filing? And I tell it, and it calculates fees, it calculates other documents that I've got to have on the way. Our technology is not there right now, but
Oh, yeah. You
it-
can create.
aspirationally, it might be
AI
nice.
chatbot do it for you right away. I can tell you, that's an easy
By the way,
one.
that will eliminate a lot of the problems that I think the pro se filers are having as well, which is what my group has been looking at, is having things returned for correction.
Oh,
The
yeah.
vast majority of those are correctable issues. They don't have a clue what to pick on the screen.
I
And
agree.
if I don't, as an attorney, I can promise you that they're guessing as well.
Yeah, Tyler can speak to that better, but I think you guys acquired somebody.
Yeah, our e-filing system has the ability to do what you're talking about. It's not, we don't have it right now in
Yeah.
South Texas, but.
So the more we move down that path and want to have that sort of assistance for filers, the more uniformity and standardization
Absolutely agree.
we need to
Yeah.
have through this, through the system.
Yeah.
Including the definitions.
Sure.
I mean, it's basically looking at the system and saying, what would expedite the filing process? And then adopting standards and data definitions to support that. And then that's it.
I think the technology is there. I think
Yeah.
if we just have a repository of all the definitions and categories and document examples, I think the technology is there off the
Yeah,
shelf.
I think that's what Tyler's saying. They have that ability.
Yeah.
Okay, all right, with that in mind, all right, what are we gonna do about 10.1?
Well, I think we're gonna add the two categories that we've just talked
Okay.
about and send it on and move it
All
on
right.
through
Okay, and
as
so,
expeditiously as possible.
okay, and I think we've just had a motion, right? We've done a motion.
We've-
So
And I'll-
it's all done. We've all agreed. Okay, good. Okay, then.
Along with the AI steps.
Okay, so Bob, what else for
We're
your
done.
standards committee? Okay, how about e-filing mandate committee?
Okay, so e-filing document access committee, we did meet in November before Casey left. It's wanted to get that in there before he left. We talked about the case notice rollout that has rolled out. And right away, they found that, attorneys didn't want every individual notice sent to them. They wanted like a daily summary of notices. So, Casey had said Tyler was working on a daily summary of notices to a feature to be sent out for attorneys. And I believe I got an update just before this meeting saying that will roll out at the end of January. Am I correct?
Yeah, it's in the next release, so it's a little lag time, probably about mid-February.
Mid-February.
Once it gets through the testing into production.
Okay, so once that feature rolls out, the attorney will have a way to opt in for a daily summary of the notices instead of giving the notice at the time of that the court integrates the order to research. We did talk about the service contacts on e-filing that some clerks were having to do. I'm not sure, Patty, if that's still an issue, of a way to deselect all on the service contacts. I didn't know if that feature was in there or not, but Casey was going to check, but I don't think we were back on that.
We have not had a new incident of that recently, thankfully, but I don't believe that we received a final answer on the fix in the system itself.
Correct. So there was an enhancement on the list to get that done, but we'll have to check with Tyler, get with Frank and see if that's something that we can get updated on. We also were still talking about the service contacts and limiting to a certain amount. We never got to a consensus on that in the committee, so I think we still need to discuss that. Along with the e-filing only option that we were discussing. As you know, from the last meeting, we were discussing that there was a lot of attorneys that were picking file only and not file and serve in some way to maybe mandate that in the rules. So we did discuss it. We're looking to hopefully maybe get something in a rules committee to mandate that they e-file and serve and not just e-file, but I don't know if that's something that's doable or not. But a large number of the e-file onlys that we were seeing were in those certain, what do you call those? Not the tax suits, but the, probation, evictions, yes, the eviction cases. Were a lot of those were coming from what Tyler says. So, possible changes to allow only e-file only on new suits, but we're still in the discussion phase of that. So we're still looking into it as the committee.
So going back, just to make sure I understand, so in evictions, it's landlords that are filing an eviction case, but they're not serving it. Correct.
It's
They're not,
I'm wondering,
they know they're trying to get,
They're going
Yeah,
on.
they're getting
they're
deadlines.
trying to get
going.
like the state paper served so they can burn the deadline.
Yeah, that's what I'm thinking.
There wouldn't be any other like requirement and to like physically deliver it to them in an eviction, like you don't have to put it on their door or anything like that.
I would think that you have to show that you gave notice. I don't know that saying I didn't know their email, so that's my notice, is that I would have done it if I could have. I mean, I don't know.
They wait
That's
2
not right.
days to put it on the door, then they're 2 days into the eviction process before the person is notified, which cuts down the response time tremendously. So the evictor gains an advantage. Same thing in the criminal side. When they paper notice the other side and you've only got 10 days to respond, well, that sucks up 5 or 6 of your days. So,
But wouldn't your deadline to respond be calculated from when you actually received, be it paper or email?
it depends on what in a death case with an execution, no, your deadline is the day of the
Right, well, that's,
execution.
no, I totally agree with that, but
So,
I'm thinking of civil cases.
yeah, it depends. It depends.
On evictions, a lot of times the notice of service is posted on the outside of the door.
Right, no, I understand that, but then my deadline would be when it got posted, right, on the door.
Yeah.
Right, and not when you failed to send me an email, just because you e-file, so that's weird, anyway, okay.
I think the issue may be that an attorney or someone else may be emailing the email at the door.
Yeah, I think it just, they've given it to somebody to do the door and it doesn't go back in, maybe
Yeah.
that's it.
I think
Yeah,
it's just
okay, I think that's probably right.
human nature, if they're not checking one, but they're checking the other, maybe.
I think
You
you're
got
right. Yeah, I think that makes it right. Okay, good, all right, got it.
His name raised.
Yes. Who did? Mark. Oh, Mark, yeah.
Yes, Judge, and Tracy, I'm getting a lot of, hearing a lot of chatter, both online in groups and in person about, the massive amounts of service on cases that the attorneys are not on without the ability to get off the service list. And I actually got served by some attorney in New Braunfels with a letter to the district clerk along with 15 other people just to tell the clerk that I'm not on the case. And so I would, I guess, respectfully request that in subcommittee or somewhere that we might revisit the click of a button to get taken off service on old civil cases at some point. I'm going to have to jump to a state bar committee section meeting. I apologize, but I wanted to let you know about that.
Okay, thanks.
And I think that was part of that other discussion, Mark, that we had to deselect the
Yeah.
service contact, which is what the clerks were asking for too. When they get put on to cases and like, I'm not supposed to be even on this case. You know, kind of deal. So we'll check that with Tyler. And then, yeah, if there's something that maybe the rules committee can work on to potentially mandate those filers to e-file and serve, unless it's a new suit or something to that effect, so that at least there's some kind of.
Well, if you're, the thing is, if you're doing the door, that may be their best way of service, that they're e-filing, but they may not know the email or anything else. They want to make sure the tenant has actual notice. And if I were them, I can understand why they put that on the door. So what do you do in those cases?
You can write a rule that says if you e-file, you must e-serve unless email is not on file. With all attorneys, the email has to be on file. If you've got a pro se defendant, then that.
But most of your
Then you're not
evictions
violating.
are pro se, aren't they?
Yeah.
Most of them
And you're
are.
not gonna know their
They may still have emails on file though. There's a lot of
Right.
pro sayers who are in e-file Texas with their email on file. So
I think we talked about the fact last time that it wasn't about cost, like they could notify and
Yes.
still stick something on
Yes.
the door. It's not precluded.
right.
It's not an extra monetary cost.
Right.
I'm just assuming that possibly they don't know, they don't have a current email on the person, you know, and so, you know, I guess they could try an email and then put the paper on, but.
That's gonna be the problem with the pro
Yeah.
ses, is you don't really have any way of knowing whether they have their email address or
Or
not.
whether, yeah, or whether they're checking it or whether
Or
they're,
actually
yeah,
just say,
I'll
we
tell you,
didn't
most
know
of
their email
in
address.
Harris County don't have an email.
yeah. Yeah,
And sometimes people you're trying to evict are unauthorized occupants.
okay, you're right. Yeah. Yeah, I think that's for eviction. Unless we do a rule where you have to do both email and, or whatever course, but you mandate email and then you can do whatever else you want.
I think where this came up though is in those cases where there is an intentional paper service when they know darn well how to e-serve somebody. So I think we're trying to get past those people who are intentionally not e-serving when they can.
But the deadlines for them, and I would just need to go back and look at the tenant stuff, but deadline for them to have notice of an eviction would be when they receive it. So the fact that they get it by paper 2 days later, their deadlines don't start to run until they receive that notice, then their deadline runs. So you're not chopping them off if you choose paper over email,
No,
correct?
but there's an intentional behavior on the part of the filer to delay that. We're
No,
talking
because you're
about-
not delaying it.
We're seeing that in the criminal world.
Yeah, we're talking about two different issues.
Oh, okay, so
Talking
the
about two
criminal,
different
I can,
issues.
yeah.
We want to stop the intentional misbehavior of the filer by saying, if you can e-serve them, then you must.
Right, because it's not just the eviction cases, it's the debt contract, it's criminal. Some of them are in the millions that
Okay,
are.
are we
being served
talking
on
about lawyer to lawyer cases where you're concerned? Is it?
it. Correct,
Well, you,
yes.
okay. That, I agree with.
Yeah.
And I see, because we have the automated certificate of service, we can see at the outsource often that things got filed, and although they haven't, they're saying they served it, the automated certificate shows they do.
And that was my argument
And
when it came up about
yeah.
taking that automated service off. Certificate of
Okay,
service
but it's
off.
actually showing us that they didn't do what they
Yes,
said they
sure.
should in the document, so I think it's useful.
I think it's very useful.
But, why let people do that from lawyer to lawyer service? I don't know, because they're required to be in the system. They're required to have a preferred e-service.
Yeah, no, that doesn't, and
So
that wouldn't
that-
bother me. I thought we were
Yeah, yeah.
talking about the
Yeah, I think
vast majority of
were.
people in eviction
In
cases
eviction
are.
cases, but getting off of eviction.
Yeah, yeah,
cases
get off eviction
and
and
getting to
talk to me
the-
about other
the
stuff.
lawyer to
Yeah,
lawyer,
yeah.
It seems to me that shouldn't be possible. Like if you're.
You shouldn't be communicating, I mean, you shouldn't be dealing with the
And-
client and
yeah.
doing anything if you've got a lawyer. No, I totally agree with
Yeah.
that. I'm sorry. I just thought in eviction cases, the vast majority are the renters or whoever that you're trying, or the people that you're trying to evict.
But getting back to the lawyer to lawyer.
Yeah,
Where they're in the system and they're required to be in the system. It seems like maybe there's a technical fix to that. I got it. Like, that you can't, like, when I go to file, it just gets served. Like, why do I have to choose file and serve? Why shouldn't, whenever I file something, in a case with lawyers or lawyers, it gets served? Why is that an option?
And like, yeah, I agree.
Are you filing something with the court?
yeah, I don't know.
Have to get served.
Well,
I don't, Tyler, you guys. it
I
could
mean,
be
normally you have a
thoughts on
certificate
that?
of service and deal with it, so I don't know.
You guys have thoughts on that?
Well, it can be required, but it'd be broad strokes. So we really can't distinguish whether the parties on the case are attorney, pro se.
Yeah,
It's basically just a data field level requirement that says you cannot uncheck this box for file and serve. You have to do it. So you'd have to be responsible for an email address. So if we wanted to go there, we'd have to pursue a way to have exceptions in there, whether it be based on a party, whether it be based on evictions. We know evictions are going to be high pro se case types. Let's omit them from this
yeah.
logic.
But you can serve yourself.
Just
I
a second, I'm
mean,
sorry.
there's always something
Yeah,
you can
there's-
serve because
you
you
could-
can serve yourself.
You could put in junk email.
Right.
I guess the issue is gonna be discovery, because discovery is not supposed to be filed, but I wouldn't be choosing to file discovery.
I thought we
Usually they
talked,
serve it.
I thought we talked about
Yeah.
2 meetings back about in certain contexts, maybe criminal cases, I don't remember, where there were filings where there was like it would be improper to serve the other side. And I kind of say off the top of my head, I don't recall what those instances were. But we had a discussion at the time about why don't we serve everybody?
Executed,
Right.
expert or witness.
Yeah, I guess that's what we need to figure out.
An
It's like,
expert.
what circumstance would it be where you not want something filed with the court if it gets served on the other side? Which
Yeah.
seems like it'd be very small.
Agreed.
Okay, so if we're gonna go, when I file something, so I can push no service, correct? That's our issues. People are pressing no service, and so it's not going anywhere, is that right? And it's just
It's only
sitting there
going
as
to the clerk.
unserved.
It's only going to the clerk.
So it's only going to the clerk, okay? So I'm trying to figure out, are there any legitimate reasons? There are some legitimate reasons why you would do that, right? I mean,
I can't
I
think of
don't,
one, but I guess maybe in a criminal.
Yeah, definitely. in criminal
in
context.
criminal,
When you not serve the other side?
yeah,
When there's like an ex parte request for an ex.
yeah, no, that's what I'm saying, it's on the
Yes.
criminal side, I'm thinking the
Yeah.
civil side.
We have parental rights termination cases sometimes where kids are moved to a spot and are filings through the Attorney General's office. I believe some of those that may have
Yeah,
disclosed information on what the kid is or something.
well, no, those are served.
Yeah.
Civil. Yeah, I mean, it's
Reveal that, never done one.
But what do we need to do to move the ball on? Maybe.
It's just some kind of language to add to the rules, potentially in the e-filing rules, to have some kind of language in there. They must e-file and serve unless it's with these exception kind of things, just like you have the exceptions with, anything else in the rules with birth certificates. and
Is that-
deaths and stuff.
Is that a rule of civil procedure?
I think it's an
update?
e-filing.
Probably be the e-filing rules for criminal cases, at least for us, and then there's some e-filing rules for civil
So-
cases. I don't know if that would be, I mean, we could always coordinate something like that.
I can't remember what the rule says off the top of my head.
I-
I feel like it says something like you have to e-serve it if you can and.
Well,
if
well,
not,
I think you have
email
rules
it.
of civil procedure that says you have to serve, right?
Yeah.
And so I'm just wondering, so is there, and I need to go look at that, and look at it, to see precisely what it says. It just,
You have to serve could be served a number of ways.
Right.
There are notice requirement rules.
right,
But notice is notice. Is that paper?
Could be
Is that
paper.
electronic? Is that telephone call? Is that by a runner? There's many ways to give notice.
yeah, no, I understand,
So
I
it's-
understand, I'm just trying to
specific.
figure out the circumstances in which. What other, there are rules in place that require you to serve the other side, you have certificates of service to
Yes.
prove that, right? And so it's really a bad thing, and judges find it to be very bad if you have filed something and haven't served the other side unless it's these extenuating circumstances. So I'm just trying to figure out the problem we're trying to solve, and that is that people are filing and not serving.
Not e-serve.
Not e-serving,
They're
but they
delayed.
may be serving a
They're
different
delayed
way,
serving.
which the rules of civil procedure allow. That's why I'm saying, I don't know that we can do something through e-filing if the rules of civil procedure allow people to do that.
We have to look. at the rule.
You just need to look at the rules, but I think it's a very good question. It's a really good one, because
I think.
And we're not bound by the rules of civil.
oh, no,
So-
I think you guys definitely, need for criminal side for sure. Yeah, if that, well, I'm just wondering for civil, if we can even do it.
Yeah, we can do it. I mean, you mean like our group, can we change the rules? We can't change.
No, we can't do it, which, yeah.
But we could certainly recommend.
Yeah, no, but we can recommend it, and that's worthwhile. I just wanted to see kind of what format we would do it.
I think we would do two things. We'd have it in the standards. and
Yeah.
The options, like, hey, change the rule.
Right, right. Okay, yeah, no, that's true. Okay, who wants to look at
Yeah, I mean,
this rule? Let me,
it
you and
sounds to me-
I can look at
It
the,
sounds to me like we need some information on the criminal side of it, and obviously that's.
yeah, no,
we're-
you definitely.
We're looking at the rules,
Yeah.
and we've been looking at this issue
Okay.
through this committee, so
Okay.
it's kind of in progress.
Good. So Tracy, will you let me know when you're, I just have a real interest in this, so let me know when.
I personally can't think of it.
Oh, yeah, okay, we'll talk about that in just 1 minute. So just add me to that, okay, and just let me know next time you're meeting on this issue on the civil side, just, and in the meantime, I'll go take a look at the rules and just kind of figure out.
Well, I think this one actually has to go to the rules. Who's in charge of the rules?
Justice Shank, presiding Judge Shank, so, sorry, trying to write judge and justice at the same time, doesn't work. So we are supposed to be getting, we just issued our order appointing a new rules committee. So we are
Okay.
supposed to be having a rules committee coming up. I'll let you know when that might be. And then we can raise this. It's been a while since we've had a meeting, so.
Okay,
We're kind of rough right now.
so you're talking about for JCIT and rules, is that what? Correct. Yeah, so. That's my committee here, let's. Circles.
Yeah. You know, it used to, that e-filing
So
document.
just go under e-filing.
Yeah, e-filing document access.
So yeah, so if I can know when they need, then we can get that information for them.
Yeah, absolutely.
I just want to reiterate on the application side, we can't turn that on unless it's across the board. So make sure y'all understand that if you put it in the rules, they just have to abide by the rules, right? It's not something the system is gonna
That the
stop them.
system can force them to do.
Correct,
I,
because if we turn it on and it would be for everyone.
For everyone, no matter
But-
what, at the
But for,
current
but
state.
for a new suit,
New suit,
you can have it follow.
differences, correct, for new
Right.
suits versus subsequent
Subsequent
filings, we
filings.
can make a differentiator there, that is correct.
And I think what we're talking about is only the subsequent filings.
Right.
And not the new suits.
And I think by default, we already have it set up as e-file and serve, so the people are having to go in there
And change.
and change it.
And they're doing that 50% of the time, which is really odd.
That's what I mean. I was trying to
I'm just
figure out why.
I don't know why.
So here's what the service rule says. It says mechanism, electronic filing must be done through the electronic filing manager established by the Office of Court Administration and an electronic filing provider certified at the Office of Court Administration. That doesn't tell you about service, so it's not filing.
So it's 21.
Anyone.
Yeah.
Yeah, we have a rule issue.
Yeah.
That rule actually needs to be updated because it
Yeah.
still talks about, filing when
Yeah,
there's no electronic filing.
yeah.
Uh,
No, I agree. I think we recommended a couple of years back that maybe we should look at it, update, or they ought to update Rule 21, and I thought it was gonna be. updated.
Sure, that was true.
Yeah. Yeah.
Next steps.
Let's modify 21. I think it needs to be updated.
Yeah, I don't.
Unless they did it in that Supreme Court order.
No,
No.
I think this
No.
is the current version. But
I'm sorry to interrupt. Are you looking at 21 or 21A?
Oh, it's
21 A's,
Okay.
yeah, for service.
Because 21A1 says a document filed electronically under Rule 21 must be served electronically.
Okay, there it is.
That's right.
And it says through the electronic
Mhm.
filing. Is that right?
Through.
Then if the email address is not on file, then it may be served on that party under subparagraph 2.
Yeah, if their email is not on file.
That's right.
That makes sense.
But that would mean attorney to attorney, they are all on file.
Yeah,
so
yeah.
they should- They're
Exactly.
just not following the rule.
Right, so
Yeah.
that would make it a requirement to be e-file and serve for every subsequent file.
In civil cases.
Yes,
Right.
I think we should just change that and not let people opt out of electronic service when they're filing
Right.
on the civil side.
And so these are the filings are motions? Are they family law?
Well, so.
They're across the board, right?
Okay.
Tyler sent us a spreadsheet of each case type. And the counts that are e-file and e-file and serve and e-file only. And when you look at the grand totals, and so this is majority of it is all civil and family.
I want to say, I want to say real quick, we see this on the appellate side, like I said, where it's showing, they say they served it electronically,
But it's not.
but it's not.
Yeah.
You can see from the certificate that they actually didn't serve anyone. And so sometimes it can be a mistake. I mean,
Yeah.
still,
Yeah.
like we were talking about before, the staff. They don't know what to choose. I mean, choose the wrong thing.
Yeah, no, and there's no
There's-
systemic issue with this.
So I don't know what the date range was that they sent us this, but out of the 12 million filings, 5.7 was e-file only and 6.8 was e-file and serve. So you're looking at about half
Wow.
are e-file only. And it just doesn't.
How long have we had email and server, right?
I just don't.
I don't think that many, it's right.
Yeah,
It's
they
not
Not long enough for them to know that.
Correct.
Because it's just so.
We
much
have
more
seen
than
where
being
someone
able
will
to-
I just
and then
wonder
turn around
what
after it's
is in,
accepted, take doc, do service only.
yeah,
Yeah,
If
so
there's
there's not
something
correct,
up, that is way
correlate
too many to be
this envelope
needy
involved,
intentional
this envelope
people just
service
not wanting to
So-
send it to the other attorney. I'd be so thrilled it's electronic, the no more of this
Right.
hand delivery stuff or anything.
It could
So
just be
debt
emailing the
contractors-
other Parties too, I'm sorry to interrupt.
Oh, they're not going to the system, so they
Right, like,
email it
it's
and
just an
send it.
option to do it through the system, but like, they could just be emailing it.
Yeah,
that contract, 1.9 million was e-file only and only 561,000 were e-file and serve. So double the amount of those filings were.
Is there a
e-filed.
cost to the serve part for
No,
e-file
no.
and serve? There's not, right?
No.
So what?
To be fair, 21A still anticipates service by mail, commercial delivery, fax.
Right.
Yeah, no, I know.
So if it allows it, and they want to choose it, then why?
That was my issue
File and serve.
with it, but.
Yeah.
Yeah.
So there's, I mean, that was the biggest, I think, was that contract. Was e-file, but I don't know why.
Okay, that's really a mystery to me.
That's why Casey brought it up in our committee. Cause it's like, it sounds to me like it's an easy fix just to make them e-file and serve on civil cases. And on any subsequent filing.
But see, I just wanna know why, I mean, to get to the root cause of why this is happening, is there something that they're hitting? I mean, I just can't believe that.
They actually have to change it. Cause
That's what
think
I,
default
lawyers
e-file
are
serve,
lazy
right?
and so is everybody
Yes.
else. Why are they changing it? I just,
Wow.
You know, could it possibly be a year, when we first started e-filing, it didn't get served until it was accepted,
yeah,
but that has now changed and it gets served upon submission.
yeah.
Could it be something like they're not
They just
wanting
don't know.
to until
Yeah.
it gets accepted? And then Evan even mentioned earlier that there's not really a way to differentiate, like they may go and do an e-file only, and then once it gets accepted, they go do a service only.
That's
So
a
there's
really
no
good
way
point.
That's what I'm wondering.
Because
Yeah,
sometimes we're returning things for correction because they don't have a certificate of compliance or they don't have the certificate of service in the actual document, or something is misstyled or something like that. So I think that that's probably right, is that they're waiting for the acceptance from the court because they might have to go back and change something. And if it's returned for correction and they refile, it relates back to their original filing date if it's after the fact. But they want to ensure that the document that was accepted by the court is the one that is served on the other part. You know, because then they'd have to serve them again.
okay, so I have, I mean, what I would, I'll do it anyway, but what I think I'll do, so I'm on the litigation section for the state bar, right? And I'm the past chair. So why don't I send out, just so we can find out what lawyers are doing, to see what they are doing, just to see what the root cause is, so that we make the correction somehow that's needed, and not, not kind of be blind as to why 60% of people are opting out of something, when they would smoothly go the other way. So I'll just send around an email and just ask the group, have you run across this? Is there, and so, and maybe ask their paralegals, because that's probably who's doing a lot of this filing, right? Is it the paralegals doing it? And that's really, I'll ask them to ask their paralegals kind of what's going on with that. And maybe get an answer, but I think, yeah, something's really wrong. So if we decided to, and I just need to look closer at the rule, is the reading of the rule such that if you serve if you serve a motion by e-filing, and that you have to e-serve the other side as opposed to use certified mail and everything else? Is that, Judge Hine, is that what you're saying?
The rule says that if you filed it electronically, you have to serve it electronically. I just moved out of the rules, so give me a moment here.
It doesn't give a preference. It just
Right.
says, right.
Unless there's no email address on file. So I'm scrolling, just give me a moment. It says a document filed electronically under Rule 21 must be served electronically through the electronic filing manager if the email address of the party or attorney to be served is on file with the electronic filing manager. Then it goes on, if it's not, then it may be served under by mail, fax, and so forth.
So I think we need to add that to the criminal side. Criminal files.
Okay.
I have to go reread those two.
Okay, can we take this up again then? Let's take it up. Let's talk about maybe adding that to the the criminal, some similar language.
Yes.
And then figuring out if we just can't come up with any explanation, how do you reinforce an already existing rule of civil procedure if they're not following it? You know what I mean? Yeah. I don't know how you do that. Or is it just not being captured because they're subsequently e-filing it separately through the system? As you suggested.
You serving it
He's serving it separately. You know, they wait to see that the document was filed and then they serve it.
Well, the rule doesn't say that it has to be one motion.
Right.
Or one fell
One-
swoop. I mean.
Yeah, that's what I mean.
Like, I can understand if a paralegal's like, I mean, it would be really embarrassing if it got rejected and the notice of that went.
Correct. So they
So-
might be doing a subsequent,
Yeah,
and is,
yes.
are we capturing that? Or are you just capturing people who at the same time that they e-file,
Oh.
e-send?
You can pull
Well,
service only.
E only and e-filing service only with that. We didn't look
Yeah.
at service.
And there's just not really a great way in the system to.
Oh, it would be
correlate the service. only
Case by
to
case,
e-filing.
you would have to
But
see,
we could pull all the same metadata, so you can kind of maybe take a.
do a surmise,
Yeah,
like
just like a
see that at
subsection.
least, for goodness sakes, 40% of the 60% are
Yeah,
all the
or if you have an
subsequent, you know what I
overwhelming number
mean?
of service onlys, that may be the kind of the missing piece of the puzzle here.
Do you mind doing that? I mean, that would be so helpful to determine, kind of
Probably.
get a better idea of what the heck is going on.
Is it
Why?
difficult to say that something will occur in the system if it got accepted?
So if it gets accepted, yeah, there is an email that goes out if file insert was.
But what I'm saying is, like, if it didn't get accepted, there'd be nothing that went out.
So because it's served on submission,
Mhm.
if we change it back to
Yeah,
served on acceptance, that's what happens. It doesn't get served unless it's accepted.
So why did it get changed in the first place?
I think because there was I'm just making an assumption here, so y'all correct me, but I think it might have been the timeline on some people from it being filed until it's accepted. So maybe if a jurisdiction, it takes 48 hours. It still was getting,
where you can get a hearing on 3 days.
and it still is getting the date at the time it was submitted.
Yeah,
And
yeah.
so then they're not accepting it for a couple days.
Okay, but if it's served on submission, then that runs that precise risk that people are either gonna say, don't serve it because it may get rejected. Or it gets rejected and all of a sudden, here is some service of a document that, well, now I have to
That is
change it
correct.
and resubmit it, so.
Is there a way to do it on both ends? I mean.
Can I pipe in real quick?
Yeah,
And
I'm sorry to interrupt. When someone submits a filing before it's accepted, we still get notices, the standard format notice that something's been filed. And then when it's returned for correction, we also get the notice this has been returned for correction. Right now, it doesn't come with the documents attached that have been filed. But I think the lawyers who are already on the service list for a case get emails every time someone at least tries to file something, as long as they complete the process and Tyler sends out the notice. They at least know someone's attempted to file something. And you can look at the description of the document to see whether, what the filer has described it as. So, just keep that in mind when we're talking about what notices are going out and so forth.
I think if that's true, then the so-called reason for not wanting, a notification, it may be that they don't know what's actually happening. Like, they don't know that all these pings are happening anyway.
Well, if it's an attorney, they're also getting it on their side when they're.
yeah, the notice goes to everybody.
Respondent.
But I think what maybe happened, I think you could have a situation that they're after served. They're just not served at the same time, in the same way. That in fact, the next step is after they file that, then they go and do it separately just to make sure. And maybe they're thinking wrongfully that that's the way they get the certification that they were e-filed it, because I don't know. But if somebody doesn't understand. And
I
I,
may still think that one is filing. Okay, and now the next
exactly.
step is to serve this, so I'll use.
Yes, and that's what I bet you, and I'll bet you there's a ton of paralegals or non-attorney, or it could be attorneys even, that think that, and think that to be super safe, they're gonna do a separate service after. We'll find that out if you will just do a quick run and kind of we don't need exact by any means, but just the breadth of these separate services that come
Yeah, just the
sequentially maybe
numbers.
after.
Now, keep in mind, some service-only filings are gonna be like discovery.
Oh, yeah,
So
of
there's
course
gonna
they
be
are.
some other stuff.
Yeah, but I mean, if it's
intentionally
like,
not
I mean, here we have
to-
60%, looks like they don't send the
But we could pull
document.
things like the service description, like what do they
Yeah,
describe it as, the
Yeah.
case number, so you could, in one sheet, look at the case number, then the other one, say, okay, I can kind of piece together the flow of events.
yeah.
Side comment on this.
Okay.
In practice, in particular in debt collection cases, they may be filed, but they can't be served because people move.
Right.
They don't know where they moved to.
Right.
And so, as a judge, I would wait a couple years, and if there's no service, I'm gonna dismiss for one prosecution.
Right,
And thousands of cases like that.
yeah,
Because they couldn't find an updated address, so I'm concerned about, you do an e-filing, but it wasn't served, and what are you supposed to do? A lot of cases, they never get served.
So the case just, the eviction case or whatever, the old collection just sits in the system during that
Yeah.
time.
It's,
Say people have moved on and done other things.
yeah, and the
And
court,
we have a lawsuit on
yeah,
file.
so
that
the
ultimately
court
gets
has to
lost.
say, well, how long do we want this case to be sitting out there? And so I used to wait 2 years, and I would set them, notice the parties of a dismissed for one prosecution, and if they didn't show up, cases were dismissed.
okay, well, we're gonna move on. This is a
Yes.
very intellectually stimulating situation, but I think we'll,
Last thing on the committee that we discussed in our last meeting was, the fees, the letter that our office sent to Megan. And we discussed that in our meeting, and it was discovered that when the orders are sent to research taxes and the parties on research taxes get the documents, though the people that are only getting the documents for free are the ones that have an email address and are connected to the case. So if the clerk says, here are all the parties and their email addresses, those are the ones that are gonna get the free copies because they are the party to the suit, everybody else would not. So,
So is that what Harris County was doing right now or no? They were
correct, that's what we were doing. So since that was, we're doing apples and apples and we're doing the same thing, we were fine with that, so we didn't go anywhere with that. There was no need to go anywhere with that discussion, so that was finalized during our last meeting, so we're good with what's set up in the system. We just have to remind the clerks, which we're hoping to do at the winter conference, that they need to send those email addresses with parties. If it's in their CMS, the CMS integration needs to send that as well.
okay,
So that the parties could get their free copies on research taxes.
okay. Now, there's one other thing, and Bob mentioned it to me, and it's electronic return of service.
Okay.
And so, Bob, you said that had come up.
Yeah, remember at our last meeting, we had some folks that appeared and asked for mandating in the electronic return service, particularly constables and sheriffs.
Gotcha.
And our response at that time was we look into it, but we wanted to make sure that we talk to the Sheriff's Association, JP Constables Association, and get their thoughts on all that.
Okay.
And I've got some contact numbers for you. Then I'll shoot to you.
And that is the next agenda item. Yeah. And then Laura, are you still on? Do you want to bring up, Laura was saying there's still some issues with the notices
Okay.
being sent by file Texas?
Yes, so recently within the last 2 weeks, I would say. Our Mobilize, which is our listserv, if you will, for the Clerks Association, there were a few clerks that were asking if in fact they had heard from attorneys in their counties if they were getting notice. And there were quite a few of them who said that the notices were not being sent correctly to the attorneys. So I don't know. I'm sorry I had to step out. I don't know if Tyler addressed that in their presentation or any discussions if they've, but apparently it seems to be an issue. So I wanted to ask about that.
You know what? Tyler has not presented yet, but I'm going to ask them to present, like now. So maybe, Laura, they will address that issue.
Judge, I'll look at Mobilize right now and see if I can pick up who the counties are.
Okay, great.
I'm sorry,
Thank
I
you.
don't have that written down.
Okay. 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 So, Tyler, would you like to do your presentation?
It struck
Kelly's the driver.
You have a presentation?
me. I do.
Can you send it to me?
Yes.
Sorry.
Since it's a Davin amendment.
He did not send that to me.
Okay, let me forward that on to you.
Or we can go on to the e-filing mandate communities.
Okay. E-filing mandate committees, perhaps for JP courts and other non-pro se filers, responsible sheriffs. We just talked a little bit about that for returns of service. What about JP courts? How do you feel about that?
In terms of,
An e-filing mandate?
don't like it.
Okay.
And the reason is, we're already getting substantial, virtually everything that's coming in is coming in electronically
Oh, okay.
already.
Is it? Okay.
Yeah.
So it's a problem. It doesn't necessarily.
In what counties?
Yeah.
Yeah, I can say for Harris County, I can't say for all the other counties. Maybe I can get some guidance from,
You have that.
I think just
Don't you have a slide usually in your presentation about the
Yes.
how JP boards are?
Then why don't we take a look at the presentation and you can talk about that issue?
and then when you get the justice court, I addressed this in our last meeting.
Yeah.
And I'll reiterate that when we do that.
Okay.
I thought the problem was with, service of subpoenas and that clerk's offices had stacks of paper they were trying to get through. I don't remember who spoke about that. And I wasn't aware of the problem until that person spoke at one of our previous meetings, but the clerk's office was talking about that, at least in Bear County. That would be wonderful if a lot of these process serving issues were they were alleviated from having to handle stacks and stacks of paper because there was mandatory.
Yeah, that's what we just sent over to Tracy
Gotcha.
to take a look at that specific, at the, I forgot who was here for that, but that's exactly.
I guess I could free
It
up a
was
lot of
easy,
time.
easy search. They did a for easy search.
Oh, okay.
Yeah.
Tracy, I think I need to be on your committee
Okay.
because so much of what I'm doing on pro se filing is largely dependent on what we're doing for general e-filing, so I probably need to be included as part of that
Okay.
discussion.
Yeah, and we did need a judge on the committee.
Yeah,
Or
definitely.
we needed somebody to help.
We're talking about the e-filing, document access.
Yes. I mean, it's hard to parse out pro se filings on a lot of this stuff because it's the same general problem that we're having for attorneys as well. And so we're probably working hand in glove on those two things.
Okay, Tyler, you're up.
Okay, with permission, for the sake of time, I can kind of zip through some of the regular stuff and camp out more on the research side. So this is our typical slide that kind of shows the volume of transactions that come through the system. As you can see, not surprisingly, around the holidays, we see a pretty big, fall off the cliff in the last couple of weeks and month of the year. Still hanging about 51, 52K filings We always tend to trend around 1.3 to 1.4 million fees processed. And the state provided filing portal, so eFile Texas is dipped a little bit. We were around 78%. We're now around 75%, which is not uncommon to see kind of vary. And then we have actually this line down here, 21 out of the 20 top 22 is actually incorrect. We actually have 22 out of the top 12 counties with JP, have some sort of JP representation. That's we had Jefferson and both had all go live with some JP precincts as well. And we actually have 9 active and pending JP engagements. So the JPs are kind of onboarding themselves sort of organically. And typically what we see is one office goes and then almost within a couple months, like clockwork, the next few offices will come and say, hey, we actually want to participate as well. We're seeing the benefits that this other precinct's have, and we want the same as well.
So what is the percentage of JPs?
I actually have that spreadsheet. I think it's about like 60%. What was the?
Yeah, so what I did in the report back in September was say, okay, let's look at this by population going from the largest to the smallest counties. And what we found was that there were 60 counties that were e-filing in justice court. And they represented somewhere around 70% of the state population. And another 9 counties that were not in the top 51 in terms of population were also e-filing. So that's how we got to 60 counties. Well, 60 counties out of 254 doesn't sound like much, but when you look at it as a percentage of the population, it's a big number.
Yeah.
And so my echo was, don't mandate e-filing. It's happening organically and smooth. From my first report in 2019, it's substantially improved. And back in the day, the top 16 largest counties, there was only 11 that were e-filing, and I got a lot of feedback from the counties that weren't e-filing. And all of those counties are, but we have the 51 largest, and this was from the last time, we had 13 counties where they're filing in some courts, but not all. And so we've gone through and identified which courts are not e-filing by county, and then Jess and I were going to get in touch with those counties and find out why they aren't.
Perfect.
Okay. We didn't get too far in the holidays and everything else, but then there was 14 of the 51 largest counties that weren't e-filing at all.
Okay.
And so if we could get those, and we've identified those, we've targeted them, we want to go talk to them, find out what's going on and why. Is it personnel? Is it budget? Is it commissioners? What is it? You know, that's keeping you from doing that. So our first target is the partial e-filings, and there's one county has 8 JP courts, and only 1 is e-filing. Why are the other 7 not? Harris County, we were blessed. We have a great court manager and former court manager. So in Harris County with 16 courts, we do everything for all 16 courts. No problem.
Good.
But the smaller counties got to be a nation.
Okay.
I keep going.
Judge, excuse me just for a minute. Of the counties with a population of 1 million or more, are all those JP courts e-filing?
I believe that's
No. The answer is no. I don't have the data right
Yeah,
now.
No, I just wanted to.
But the answer is no. I didn't bring with me, in fact, but my computer at my son's house. So I'm gonna have to go back and get it. But the 51 largest counties, I think you get the counties that are less than 1 million. I don't remember how many are more than 1 million people, but I didn't like that threshold. I wanted the 51 largest counties.
Right, but the largest counties have
It's like
significant,
Dallas, Barron, Harris,
Houston and Houston
Dallas is
sounds
not
like
half
everybody's
rolled
doing
out.
it,
All the
right?
16 largest counties, all courts, they're doing it.
Yeah, that's what, I think that's.
Wait a minute, but yeah, no.
That is
That's where the difference comes.
I'm sorry. I just want to make sure it's clear. In Dallas County, not all of our JPs are e-filing. Or accepting e-filing.
And see, and to me, that is the issue in the counties of 1 million population, which I think Colin up to Harris.
Yeah.
If lawyers are having to guess who e-files and who doesn't,
Right.
it seems like we should talk about at some point, when is it time to mandate that? Giving everybody time, giving them, we have never done a mandate and not given people at least a year. And in some cases more.
And we
So-
can do that with size of population that makes it a big bang we don't have to do.
Well, just
everyone.
remember that they might need infrastructure in terms of support from their counties. I'm just thinking,
Right.
And all of that sort of thing. Yes.
Well, and what is the percentage of cases filed in JP courts that are attorneys versus pro se?
Yeah.
Because we still have not mandated e-filing for pro seers.
Right.
So are we only hitting 30% of the cases if we mandate e-filing for JP courts? That is something that I know my court would want to know before it would even consider.
Yeah, large counties take a look at how
And
that.
it depends on the case time. So if it's a debt collection case, it's about 92% of filed by attorneys.
Okay, but if we mandate and if the Supreme Court mandates, that depends on, what percentage of cases is that? If debt collection is, 50% of the cases filed, then that raises that threshold. If it's only 10% of the cases filed, then 92% being lawyers doesn't matter.
Yeah, the
Because
other
the other
eight,
90%.
the other
Okay,
8% are usually.
I'm gonna have to call a halt because we
Yes.
gotta have Tyler present
Sure.
on
Yes.
everything. So I'm so sorry.
The other
I-
8% are stewards.
Let's do a deeper dive into the JP stuff. And we'll put it on the agenda for next time. And so that way we can answer questions. All right. Thank you.
Go
Go
on. Go ahead.
I'm sorry.
You're fine. And then this slide around the return for correction, just broadly speaking. Again, you see the dip down in the last quarter or so. When it hits the holidays, everybody kind of goes on vacation last 2 months of the year. Move on to the next one. It's a little bit deeper dive into the data behind the correction. So the typical slides we see here, the usual suspects, obviously the more higher volume cases, you're gonna have the more higher return rates. One thing I'm trying to do when I pull out the data is be a little bit more thoughtful over what impactful case types we're seeing. So you don't see the same kind of cases regurgitated over and over. So this, you start to see a little bit different cases kind of cycle through, like maybe they're not as high volume, but if there's 8,000 cases filed and 4,000 of those are returned, 50% return rate, like that may be something worth digging into a little bit further. Like, why are these specific case types maybe lower volume, but why are they such a high miss rate?
The filings in small claims court, 94% get returned in JP court.
Which one? Oh, for this one? Oh, this is what percentage of the case category. So what percentage of other civil does small claims comprise? So it's about 94%
Oh,
of that
because
category.
it's adjusted.
Yeah, yeah.
Okay.
So small claims is gonna be the overwhelming majority.
I got you now. Return rates.
Yeah, the return rate's the next column, and I can swap things around too. And then these are the return for correction rates, just historically, because I know one of the big concerns was mostly around the filer request and judge's request.
Yeah.
So filer's request is actually taking a dip in terms of, historical averages, which is kind of nice. So that's going down, but the judge's request is going up a little bit. And it may have to do with maybe more proposed orders are being filed, and that's just kind of how they handle the projection process.
So let me ask you this question, because I did the breakdown as far as pro se litigants go on why the subcategory of judges requests. We actually looked in the comments and it seemed to me like, about 47% are opaque, like call me or call the court coordinator. Who knows what that means? But then a lot of them were things that we already have in other categories.
Right.
Failure to file fees, formatting page size, signature verification.
Huh.
So those are things that are getting through the clerk that the judge is then flagging and saying, I'm returning it for correction.
Yeah, or it's just they're picking an easy one, either judges,
Yeah,
filers, and just typing,
Everybody's
hey,
just
call me,
doing
it's
judge
easier.
request.
Sometimes it's, hey, it's just easier for you to call me and I explain where you went wrong versus typing it all. I mean,
Well, if it's something in the standards or something like that, we'll say incomplete or incorrect.
right.
And say you didn't follow the standards. We usually won't do judge's request.
Yeah.
For us, but I don't. it's good.
Well, and I will say this, of the counties that are using judges' requests, there's a wide variance. I know McLennan County, for example, just kept popping up higher percentage of the return for filings. I'm not sure there what's going on.
So this is our guidance file, just sort of the raw metrics behind it. So the top right box is the number of sessions completed for the entire year. Tarrant is, as usual, kind of the overwhelming majority. But some really impressive numbers from some of the other counties. Well, of course, obviously the bigger counties are going to be are going to have the overwhelming amount of sessions. The nice thing about is the completion rate has actually seen a pretty good tick up from 2024. You see, it's always kind of hovered around 34 to 36%. We actually hit it up to about 40% this year, which is nice. And I'm actually a little excited about the next slide.
Can I ask you, sure. Are you, there you go. No, it's actually, this question I was going to ask is, all right, and yet how many of those are getting returned after?
Yeah, so the return for correction is still very high, but the one number I will point out is the 4.53% dip. I believe it was the last version of the standards. You guys put the blurb in there about if it is a guidance file submission, it has to be accepted. And we've actually seen a pretty significant drop since that's come around, about 4.5% since I believe when the first time or the first slide I pulled was about 22-ish%. So it has dipped down quite a bit. And that's the volume by month off to the left. And then the return rate is the line graph that's in the middle of there. And then again, sort of the usual suspects in terms of the case types and the return rates for those.
And we're still getting 20% judges request return on a guided file.
Right.
That is a Supreme Court form.
Yeah, so looking in the comments of those, because I believe I sent maybe you the raw data for that last time. It's the same stuff. It's hey, this filing requires a wet signature, or there's some other process where the judge needs some other form that's not part of guidance file. I will say that mid last year we did a kind of an evaluation with with Neela, one of our former guidance file authors. Basically kind of ran the program for a long time. She was able to give me a kind of high level analysis of these different interviews and where some of the obstacles were that she could recall in the notes she had. So we did send that back to Casey. I can kind of resurface that, but there were some interviews in there that with some corrective actions or some modifications, maybe some low hanging fruit that you may be able to kind of push up the adoption rate or the acceptance rate of those. And some like occupational driver's license is going to be a little bit more complicated to make cohesive.
You know, I talked to Justice Busby about this because he's very interested in pro se's and, you know, access to justice and that sort of thing. And he was surprised when I told him, by the way, when you open the door to all of the, just make your own rules. There's requirements for additional type, like forms and things like that, particularly for divorces and stuff like that, that are county by county, just different ones. And it's, which is directly opposed to the idea of providing that access through these guidance file things. And so,
yeah, my data was limited to just a couple of months. Well, we didn't have the entire year, but even in like August, September, we were still getting returns for correction because a guided file filing was in conflict with a local rule.
yeah,
And the thought is, wait a minute, if the Supreme Court approved the form, I don't care what your local.
that's, and Justice Busby said, oh, no way. And I said, oh, yes. I said, you gotta understand that the district, or the clerk of that court is gonna go with what their local rules are, and naturally. And so, so anyway, I think that's something that we need to probably talked to the Supreme Court again about, and they are now looking at the chaos that I told them would happen when when they decided that, yes, district courts could go back to making their own rules.
There may be substantive reasons why you would deny a motion, but to refuse to accept the motion
That's it.
is it kind of raises a due process issue.
And absolutely, well, it does, and and that is absolutely true. You may not like it and whatever, but you can't refuse it. So,
On the local rules, I know that both high courts were getting inundated with local rules.
yes.
And we changed the process. Was it OCA that was then?
No, they just post it on the internet. They just have to post it, right? I mean, they just had to let everybody know. I mean, that's what's.
Yeah, but it's not just a free for all. I think there were some limits on it and I don't
I think the regional judges have to approve them.
Maybe
Yeah,
that's what it was.
Maybe that's it, but then,
They still can't conflict with.
right, but they're totally inconsistent, right? And so maybe, you're back to what it used to be before they became more consistent with.
Why can't it conflict? I thought local rules could make requirements that were stricter than the general rules. I thought.
Well, they can't conflict like with the rules of civil procedure and stuff like that. Your local rule normally happens to do.
Yeah, they can be
do
more
those things.
specific, but they cannot be contrary.
Yeah.
So
To a rule of civil procedure, but that means, okay, I'm gonna
Or
go practice in
drafts
this
or-
court and I may learn that, okay, I can only present motions on this day, or I can only do something that maybe I didn't know.
They can, so that's probably what I was.
But, and my complaint was this, both the Supreme Court and the CCA have both said, we're going to construe your documents in a fair reading by what you have included, the substance of, not the hyper-technical.
Yeah.
I've got to say the
Right.
magic rule, or the magic word. When, and if those are preserved correctly, an appellate court gets to review whether the judge erred in doing that. If you go through the process of returning it for correction, that never becomes a part of the process where we get to see if the trial court was incorrect in doing it. It never gets filed. So that's even beyond our review.
Yeah.
That's what they're using the e-filing process for. And I think that's where
that's a problem.
that's part of the
That's
problem
the
on
issue.
this judge's request
Exactly.
return for
Yeah.
correction.
It's a gatekeeper issue.
Right.
It's a gatekeeper.
That should not be an impediment to filing. That may be a substantive problem, but that's not something the e-filing system should be used for a judge to say, that doesn't comply with my local rules, I'm gonna deny it.
That's true. I agree.
May I?
Judge Hine?
Yeah, so we talked about this a couple of years ago, and I thought we talked about asking the Supreme Court to revise the rules slightly, because right now it says local rules can't be inconsistent with state or federal law or rules adopted by the Supreme Court of Texas. And I thought we asked them to also, or inconsistent with the technology standards approved by the Supreme Court of Texas, because we've seen this problem. And so perhaps we could ask the advisory committee to look at a slight revision to rule 3A on local rules to clarify that local rules can't be inconsistent with the technology standards, and B, local rules cannot be, if we want to be more specific, B, local rules cannot be used to provide basis to return for correction a document that's been filed electronically.
Yeah, if I file a motion for continuance and I don't follow the local rule for doing it a certain way, that may be grounds for denying the motion. That's an appellate argument we can debate. But it shouldn't be grounds for not accepting my filing.
Yeah.
Was my point.
And it shouldn't be the judge accepting the filing, it should be the clerk.
Right. That's right.
Right.
But 20% of our filings are getting returned by judges because of judge's request.
Well, that's a title.
Yeah, and I've never understood exactly what that breaks down to be, because that doesn't make sense to me when the clerks are the ones getting the filings, not the judges.
Yeah.
And if I go to a judge's home in the middle of the night and try to get them to
Right.
sign something, that's a different. But e-filing.
Yeah.
Thank you.
Okay, there's another issue along with the local rule too, is that in the Court Administration Act, there's a section that if there are X number of courts or more in a county, there's supposed to be one set of local rules per division.
Right.
Not local. There are 50 courts in the county, and so theoretically you could have 50 sets of local rules.
When we got them, they were by county.
Yeah, that's,
Not
yeah, I
by
don't know
court.
anybody that's split it up by 4.
Yeah.
Oh, I can tell you.
What about general
Really?
orders
That's
issued by
funny.
each court? Is that considered a local rule?
That what?
Standing orders,
General orders issued by each individual court that are different in each court, are those considered local rules?
Like a standing order, yes, and they're supposed to be on the website, the Supreme Court website to be in effect.
Yeah.
If they're not,
if they're not on the
they
website, then
challenge,
they're not in
yeah.
effect.
Right.
I see.
Yeah,
Well, and some folks would tell you that standing orders were to get around not having to have a single set of local rules. They were
Exactly.
adopted by a majority of the vote of the judges of the division, or if they don't act, by the local administrative judge.
Okay, well, let's,
It's a lot of water under that.
yeah, let's let Tyler continue on and get through their presentation. And I can see that there are several new topics we need to discuss. That's my next topic. Okay.
So this is just a progress on how we're doing on the integration. So we're past the 11-1 mandate. There are still some laggards. On the statewide side, across the entire board, we're about 80% done. We have so there's 508 unique connections, 398, those are complete. So about 80% of the Tyler CMSs, we are 98% there. There's a couple, Austin, I need to update that. It's not Austin County. It's actually Kerr and Winkler County Clerk. We're working on the integration. The reason why it's taking a little bit longer is because historically they have not been integrated to the EFM. The EFM is kind of that bridge between the CMS and research. So we're actually working on their EFM integration, which is what's needed to be in place to make the research integration happen. And then our other bigger vendors, iDocket, NetData / i3 Verticals, and eDoc are all working through their own integrations as well. iDocket's got, I think, a few on tab. iVerticals actually had 5 counties go live. So they're still making progress while also developing towards our batch integration model, which that's what Tracy and Harris are using right now in Tyler as well. So it's just a less traffic and resource intensive way to integrate better performance, stuff like that. So they're making the switch. And then in terms of just Flight 3 itself, we're just under 80% there in terms of all the remaining counties. So I think there's like 70 something total remaining. And one thing I did want to touch base on is the criminal pilots. So we do actually have 2 courts that are working on our criminal integrations. That's Bear and Denton. They're actually both testing went really well. They're about the end of testing, but we did uncover, I'll call it an issue because in terms of being the way the system works is outside of what JCIT standards desire. So what is happening is that the way and I'll try to explain this best I can, that I can regurgitate what product in depth that beat into my head, is that the way the whitelisting policy works. So if you're a public user being granted access to a public case type, by the logic of the rules behind it, you're also granted access to the documents as well. There's not a great programmatic way to say you can only have access to these 5 types of documents without basically playing whack-a-mole. So we have to have some kind of inclusion and exclusion of every single code type in the system for every single county to say, these 5 events represent these 5 documents on the standards. You have to do that for each and every single office within the county. So as you can imagine, that would be really poor performance. So the couple recommendations we had, and this was before the lively discussions this morning, so some of these may be a bit moot, was either JCIT standards be either JCIT standards or a exception being made that if a document is basically marked public within the case management system, basically let the case management system dictate whether that document can be shown on these criminal cases or not. That's essentially the way Denton is set up. They have their criminal cases and these documents are either sealed or secured because they have sensitive information, they're part of a sensitive case, or it's a a kind of a general criminal case type, and the documents are public and they can be surfaced. Bear is actually in the similar boat. They want to do some internal deliberations, whether they actually feel comfortable doing something like that. So in the other one is we kind of roll it back a step and say, hey, no documents to be displayed in criminal for now, until we come back and say, this is kind of the broad stroke of documents that are going to be available versus not. So basically waiting on the documented events to be expanded within criminal law standards.
I think a bigger discussion there is we've tried to kind of get it a little, Tyler has tried to get a little more engaged in some of the subcommittees so that we can help you guys. You're coming up with rules that sometimes we can't necessarily support. So we want to get ahead of that so that we can have those conversations with you all. So I know Casey had started adding us to some of the subcommittee meetings, and we would like to continue to participate in that so we can help, put out a rule that we can't ultimately support.
Good, right. And then one more note on what Ms. also brought up earlier, if we can get examples of the attorneys in the cases, like their name or email address in the cases where they weren't getting notifications, not just their cases, but any cases, we can troubleshoot and kind of dig and see, this is a, is this a process issue, is the attorney's email incorrect? Like what exactly is preventing these specific attorneys from getting their notifications? So just wanted to put that out there.
If I may, I found I found a couple of the emails right now, and it seems, I don't know if it has to do with the Research Texas integration issue, or like you say, if it's emails, but Dana Hogg in Hardin County is one of the clerks, and then Brandy Robertson, who is a first assistant district clerk, I'm just not sure to who, is also saying that that there's documents not showing up in Research Texas, therefore the notices aren't being sent to the attorneys. So
Okay.
I can keep digging and see what else I can find, make some phone calls and try and get some more answers for you.
Okay. Yeah, if you send us what you have, we'd be happy to dig in and troubleshoot a little further and see what's the kind of the root of some of these situations.
Can you put your contact information for me in the chat so that I can get that?
I'll send it to you, Laura.
Okay, Tracy, thank you.
Yeah, these are the previous slides. McLennan will be, I could have updated that. McLennan will be integrated, I think mid-July is their go live date for the CMS. And then along with that, they'll have integration as well. These are just some historical slides in the appendix.
Yeah. Okay, good, excellent. Okay, well, we have run over. We generally try and always close by noon. We have a lot of interesting conversation, and it looks like we have a lot of things to do for our next meeting.
March 27th.
March 27th, looks like it's our next meeting date.
There's been a request for me to say what dates I'm coming. Normally Casey would send out, here's all the dates for the full year.
Yeah. Yeah, I think let's take, Bob and I'll take a look at that and double check it and then send it out. All right.
Now, the next one is scheduled for March 27th.
Okay.
27 or 2nd?
7th.
Sorry, yeah. Okay, so we'll send the dates then of the next meetings out. Right now, it looks like we have some continuing issues having to do with the service, and Tyler's gonna do some checking on why we have 60% of looking like they're not getting electronically served. Like maybe they are, but in a later time. So, and why does that happen? So we have that, and I've made a list of a couple other things so that it looks like we'll have a full meeting next time. And it was, go ahead. No,
June 5th.
All right, any immediate questions? Then this meeting is adjourned, And we will see you again next time. And thank you so much. There are people that you all have given serious consideration to these issues and some great comments. And so I'll go ahead and send out an email just to the litigation section, just to find out if their paralegals do the e-service at the same time they do the e-filing, or if they do it, or secretaries, or do it later, whoever their assistants or whatever are. Yeah, I'll see what I can find out. Okay.
Well, after surveying.
Yes, so you.
All stakeholders.
That's good.
All good.
Oh, sure. See if I've got a card.
Like going to live, but
Just.
You're
You're gonna have to stay. Please curate, please curate that.